Welcome to episode 26, Employment Law and Behavioral Health, by Nick Merkin, California healthcare attorney. From Clearly Clinical, learn, grow, shine.
Hello and welcome. This is a seminar on employment law issues and addiction treatment. My name is Nick Merkin. I'm the CEO of a consulting firm based in Los Angeles called Compliagent. What we do is service different kind of healthcare providers, both in the state of California and nationally, and help them build out and maintain their compliance infrastructure. A big portion of our client base is in the addiction treatment space, and so I welcome you if you're part of that industry within healthcare, but I will also say that for those of you who work in a slightly different area of healthcare, a lot of these issues will apply equally if you work at or manage a healthcare facility of any kind, skilled nursing facility, for example, in a hospital system or wherever. So again, welcome, and we're going to dive right into things. But first, let me just give you a few disclaimers about things. So one thing that I always need to say, because I am a lawyer, is that anything you're going to learn here today should be classified as general legal discussion, not specific legal advice to anyone individually or with respect to any potential problem that you have. I would urge you and encourage you, use the information that you've received here today for things like issue spotting to develop a certain sensitivity to some of the issues that are very common and that people who manage and work in addiction treatment and other kind of healthcare facilities should know about. But if you have specific questions as they pertain to you, as they pertain to your organizations, be sure to ask legal advice to somebody you trust, an attorney in your jurisdiction who's familiar with the specific employment-related laws in your own hometown, so to speak. And it goes without saying there's no attorney-client relationship that I'm developing with anyone in particular by saying this. And one thing I should also say as kind of a programmatic note, I'm based in California and I'm a California barred lawyer. So by definition, a lot of the examples that I'm going to give, whether it's situations or specific statutes, have sort of a California bias to them. There are federal laws, federal employment laws, of course, that are going to apply equally nationally and across different states. Many of the issues are going to be similar if you're in a state outside of California. But first of all, just like I said before, we should proceed with a little bit of caution when you're talking about the specifics. And again, the purpose of a lot of this is you are going to find similar issues and common issues no matter what state you're in. A lot of the guidance and solutions that's non-specific to, specific rules or specific regulations are going to equally apply to you. And that's really what the purpose of this and what should be internalized here. And again, if you have a specific question, if you're inside California, talk to someone who's competent to answer that question. If you're outside of California, even more so, because some of the specific, dates, numbers, dollar amounts, requirements may not be the same in your home state. So let's jump right into to some of the material, because we've got a lot that we'd like to cover in a little bit less than an hour to do so. I'll give you a little bit of a roadmap about what we hope to address today. We'll talk about some concerns with the employee interview and hiring process. There's a lot of nuances to that, and it's actually a big risk area for a lot of healthcare providers, and specifically in the addiction treatment space. a little bit about the nature of the working relationship and different kinds of policies and procedures and notification obligations that you should have. We'll talk about harassment and employment discrimination and those kind of risk areas. A little bit about wage and hour obligations, things to sensitize yourself to. In other words, break times, rest times, meal periods that might be required. A little bit about employee discipline and the termination process, and then somewhat about post-termination pitfalls and issues. So let's a lot of the way this is going to work is, just talking about situations that come up really commonly, like I said, in an addiction treatment facility or any kind of behavioral health facility. And as I said, a lot of this is going to be equally applicable across the board, wherever you might work in healthcare. But let's talk about background checks for job applicants. A couple of pitfalls to keep in mind. Generally, background checks are permissible for job applicants. A couple of nuances that apply. They should be conducted uniformly. And what I mean by that is don't create a system where you're background checking certain individuals and not others. That's going to open you up to a claim that you might be being discriminatory. Maybe you're only doing it for background checks for individuals that come from a specific race, a specific gender, et cetera, et cetera. That's going to create a lot of risk for you to do that, and it's also not the right thing to do. You are also not allowed to require the prospective employees to pay the costs of that employment screening. Okay to do that. You can't make, for example, an application fee for someone that they have to actually hand over and pay and reimburse that. That's at the employer's initiative. And therefore the cost is going to be borne by the employer. One other thing to keep in mind, in many states, the laws related to performing credit checks on individuals are complex. California included. If you're going to go ahead and make a credit check part of a background check on an employee, and this is often done, make sure you're following both federal and state laws in your jurisdiction. For example, federally, there's something called the Fair Credit Reporting Act, and there are certain steps and disclosures you need to make and certain permissions you need to obtain from the individual for whom you're requesting a credit check. So, make sure that you really want to do that. If you're going to go ahead and do that, it is a little bit of a risk area because the law does protect people's credit scores, from outside knowledge. So just make sure you're walking the straight and narrow on that, so to speak. Let's talk a little bit about an arrest record, something that might come up during a background check. So here in California, we've instituted something called the Ban the Box law, and that basically means that whereas in the past it was permissible to ask someone about their past criminal history, now there's restrictions on how you can ask that, and you can't actually make what's called a pre-offer inquiry into their conviction history. You actually have to make an offer, and then you can make it conditional on that kind of check. And if you are going to disqualify someone for a job or a position in your organization for that, it has to have the actual conviction has to have a direct and adverse relationship to the job. So, for example, if it was for a crime that happened so long ago that it could be said to be not really relevant today, that's something you should be concerned with. If it's for a subject matter that really doesn't relate to the position they're going to have in your organization, it's something minor, it's something really attenuated and not related, that's a risk area, and you should think about whether or not it's permissible to use that as a basis for denial of employment. Keep to what the law allows the purpose to be is, making sure that someone that you're about to hire isn't going to be a danger internally or externally in your organization, and particularly when it's a case of danger to clients. So if you keep that in mind, you'll wind up staying more on the right side of things. Let's talk a little bit about some other issues, like asking a prospective employee about salary history. So at least in California, effective in the beginning of 2018, employers became prohibited from seeking a salary history information on job applicants. Now, let me be clear about one thing. An applicant can volunteer their salary history if they want to. It simply cannot be required by the employer. So for various reasons, an applicant may want to reveal that salary history to his or her employer. Maybe that's part of the negotiation process for what compensation they might get in the new position. That's okay. If the candidate himself or herself has to do that, though, on a voluntary basis. So you can't disqualify someone from candidacy because they won't reveal that information, and don't ask it. Other issues that come up, and this is a question that I often get asked: social media. A lot of information can be gleaned from job candidates' social media presence. That is good in many ways because it enables you to get a more full picture of a prospective employee. However, there are some risks and pitfalls related to that, and that's the following. You want to make sure that you are not gathering information about something that would be inappropriate to ask about. For example, the fact that the individual might be in a protected category. Let's give an example like pregnancy. You can look at social media, but when you get that information, and let's say, to give an example, that it becomes clear to you that the job applicant is pregnant, and you didn't know that from the interview, you're actually prohibited from asking about that, but you see that because you look at someone's Facebook page, for example, and you see, congratulations, you're expecting type of posts on. You cannot use that information as the basis for denial of the job application. So a lot of employers will actually tell the people involved in the interview process not to look at social media to protect themselves from that, because you're kind of gaining information that if it's used improperly, or at least you have the potential to use it improperly, and that can create a risk area for organizations. So, think through how much risk you want to bear on that, how important it might be to get that information, and make sure that you're educating people throughout your organization, if they're part of the interview process, about what information is permissible to use as the basis for denial of a job application, or in consideration for employment. So let's talk about drug testing policies and drug-free work policies. Obviously, in the addiction treatment space, this is something important. You're generally treating individuals who have issues with drug dependency, having employees, particularly counselors and those with direct interaction with clients, who are, using narcotic substances or drug-related things, is obviously going to be problematic. Now, of course, in many states, and this is California included, which now has a medical marijuana policy and a recreational marijuana use policy, this can become a little bit of a sticky situation. So let's talk about the medical sides of things first. Now, you are permitted as a California employer to maintain a drug-free work environment. Let's think about it this way. Just because someone can use alcohol or can smoke cigarettes, to give an analogous example, doesn't mean that you need to permit them in your work environment. So that's absolutely fine. Just like you wouldn't tolerate an employee drinking on the job, and this is true certainly within the addiction treatment space, but it doesn't matter if you're Starbucks or, or Target. You wouldn't tolerate someone drinking on the job. What gets a little bit more complex is the case of medical marijuana, because at least by state law, and this is true in California and many other states, if it is seen that there's a medical need for the individual to, be using marijuana while on the job, and it's truly, medically necessary, you can run into a problem with the Americans with Disabilities Act. And you can run into a problem with a lot of state law provisions. And the law may take the position that denying someone the ability to use marijuana while on the job, if it in fact is medically indicated, is the same thing as telling someone, well, you can't take penicillin or antibiotics while you're on the job, which would be problematic. So, treat medical marijuana as you would any other prescribed medication, if it's being taken or if it's being suggested that it's medically necessary. That said, make your expectations and consequences clear regarding job duties and the ability to meet those obligations. Meaning, if that's true and there is a medically necessary use, you still have the right as an employer to say, if this is going to interfere with your ability to do this job, well, I can't permit you to do that at the workplace. So, that's still there. No one's saying that someone can walk around inebriated, intoxicated, or, what have you, when they're doing a job that would be impossible to do properly, if that were the case. So, identify roles and different responsibilities that have the potential of putting people at risk, and use conditional offers during employee selection that outlines the company's policies and expectations. For example, if you're going to make someone an offer, you can make that offer conditional on acceptance of the policies and procedures and the HR policies and procedures of your organization. And if one of those expectations is clearly outlined as a drug-free workplace, that has to be agreed to, as a condition of acceptance of the offer if you set it up that way. And it's a good practice. And, communicate and reinforce company policy on drug and alcohol abuse within your organization. Again, that's really good practice, and that's going to protect you. And, provide the training you need, and make sure that your managers can, have learned to appropriately identify people who might be unfit for work because of a condition, a certain narcotic condition, and, what the consequences of that might be. So let's move on a little bit to some of the more traditional issues after someone is hired. So one of the big issues in employment law, and this goes for healthcare organizations, behavioral health organizations, or any other type of employer really in the United States, is the distinction between an employee and an independent contractor. And most states have similar but pretty well developed tests, or indicia, I would call them, of how you classify someone. Treating someone like they're an independent contractor when you really should be treating them as an employee is called misclassification. And there's reasons that somebody might want to do that, and that you might want to, push someone over the line, or in your consideration, to be an independent contractor, namely because things like employment taxes, things like sick days, things like benefits don't accrue by individuals that are independent contractors. So because of this, the law is very sensitive to misclassification of individuals, because it's not fair to them, and it's also not fair to the government who's collecting those taxes. Historically, independent contractors are considered self-employed, and employees are subject to the employer's control over the manner and means by which the worker performed the work. So control in this context means things like, do you set the hours for that individual? Do you tell the individual what location they need to go to during those specific hours? Do you set a certain dress code? Are they wearing a uniform? Are there certain tools or materials that belong to you as the organization that you're requiring them to use? If all those things are true, many of those are indicia that are used both in California and in other states to push someone towards classification as an employee rather than an independent contractor. Here in California, as a result of a pretty recent case in 2018, we now have something called the ABC test. And this is similar in thinking. Again, let me caution you, there's going to be slight nuances and differences depending on what state you might be in. But this is similar in thinking and in attitude, so it's a good analysis to go through. Again, by all means, ask specific questions to someone who's legally competent in your jurisdiction and will know those nuances. But nevertheless, free from control or direction. So if you want to classify someone as an independent contractor, they need to be free from your control and direction in the ways that we talked about, and even in the ways of doing their work. That they perform work outside the business as usual work. So generally, an independent contractor is someone who doesn't do something that's exactly the same as the rest of your employees. You're going to have a very difficult argument if 9 of your counselors are considered employees and you hired a 10th and just made them an independent contractor because you didn't want to worry about things like unemployment insurance and what if and not paying payroll taxes, etc. And the last one of these indicia is customarily engaged in independent business, providing the same services as those being provided. So if someone has their own corporation, if they're, a consultant, for example, who works with a number of different healthcare organizations doing the same thing, that's going to push towards the definition of an independent contractor, not an employee. So, when there's evidence like that, make sure that you document it. And this is something, documentation is something that I would say is an overlay for all of this, particularly true in this case. When you're going through your process of deciding whether you're going to classify someone as an independent contractor or as an employee, make sure that you document your reasons. If there are things like the person has an independent company, the person works for other clients as well, document that stuff. Don't rely on the individual to get that to you, because you may have to answer this question a year, 2 years from now, and that person might not be that motivated at that time to provide you with the information you need to defend your organization against a claim that that individual was actually should have been classified as an employee. So it's a very important distinction because of the tax liability. And if you make the wrong decision, you get into the crosshairs of the taxing authorities, they can make you not only pay fines and penalties, but also back pay a lot of the taxes, Social Security, Medicare, income tax for those employees. And you would have to back pay things like overtime, meal periods and rest breaks, and more things like that we'll talk about a little bit later. So it's a sensitive and nuanced discussion, and if you need help in getting it, then by all means reach out to the person with expertise in that. In a similar vein, there's employees that we classify as exempt versus non-exempt, and it is not the same thing as employee versus an independent contractor. And it doesn't always depend on whether the employee is salaried or not. A salaried employee can be both exempt and non-exempt. So what does it mean to be exempt? So you're exempt from wage and hour laws, things like meals and rest breaks and overtime and minimum wage. So generally, employers like having exempt employees, but you have to reach a certain threshold to get that exemption. There's something called, for example, a managerial exemption, which is pretty much the one that might apply in your cases with your organization. So what's that exemption? If you're primarily engaged in what's called exempt work. Definition of exempt work: if you exercise discretion and independent judgment more than 50% of the time. So basically what the law is trying to articulate is a manager level individual can be exempt. You also have to, at least in California, earn a minimum monthly salary of no less than double of California's minimum wage for full-time employment. So in 2018, that's $45,760. Be very careful, though, even if you're from California. Minimum wage is changing on a yearly basis, year by year. Don't rely on the number that might have been true in 2017 for 2018, and certainly not on the number that might have been appropriate for minimum wage for 2018 and 2019. So I'm even a little bit remiss to give you a number because you may be listening to this at a time when the minimum wage has changed. So let's say that you have employees that don't fall under the exempt category, and those are going to be probably the majority of your employees. So what kind of obligations do you have for them? Minimum wage, for example, overtime or double time, depending on if they're, working in excess number of daily hours or weekly hours. Meal periods and rest breaks, and we'll talk about a little bit of that. You have to give them pay stubs. You have to reimburse them for business-related expenses. Things like uniforms, even things like cell phones. If you require them to have them for work reasons, the employer needs to pay for. So it can be quite a burden to have non-exempt employees, but if you misclassify, similar to an independent contractor versus an employee, if you misclassify an employee as exempt when they're truly not exempt, you open yourself up to a lot of potential liability and risk. And again, if you get in the government's crosshairs on this, or even an individual's crosshairs, because there's plaintiffs' attorneys out there that take these kind of cases, and you may have to back pay people for those benefits and those salary obligations, and there's fines and penalties that are going to be involved as well. So again, make sure you're seeking competent advice about some of this stuff. Meal period obligations. So in California, an employee gets, I should clarify, a non-exempt employee is due a 30-minute unpaid meal period that's provided no later than the employer's 5th hour of work. So, for example, if you start work at 8 a.m., by noon, you have to offer that employee an hour meal break. Now, to be sure, again, that meal break is generally unpaid, and an employee can actually waive that and continue to work for an hourly wage if he or she wants. I would encourage you, if you're allowing that you get those waivers in writing. There are many, many cases out there where an employee comes back after years of doing this, never took their meal break, and then accuses the employer of withholding that meal break from them. And the employer says, "What are you talking about? You told me you didn't want it. You'd rather leave earlier in the day and work through lunch, so to speak." And the employee says, "No, I didn't. You told me it was prohibited." And you want to be able to defend yourself and defend your organization by having written authorization from the employee and a written understanding that they know that they're able to take a meal break, but they made their own decision not to do that. There's also rest break obligations. Now, rest break obligations are different than meal breaks in the sense that, number one, they're paid. They're also only 10 minutes. And, depending on what state you're in, but I'll tell you for California, If you work from 3.5 to 6 hours, during that period, you get a 10-minute rest break. 6 to 10, you get another one. 10 to 14 hours, you get a third. And to be clear, this is different than your meal breaks. One time doesn't count to the other time. So you might get your 30-minute meal break, and then you also will get the 10-minute rest break. It doesn't, sort of meld or merge into the other or get subsumed into the other. So, make sure that you're not confusing those, and that your employee understands the difference as well, so that they don't have concerns and that they're getting what they're due. So let's talk a little bit about some of the pitfalls related to that. So, for example, I did mention that an employer doesn't have to mandate that their employee take those breaks, but you should be aware that no work can be done during a break period for it to count as a break. So if into a 10-minute rest period break, you're 5 minutes in and you then go ahead and call the employee and say, I really need to talk to you now, or you just really need to send this one email or answer this one call, even if the email takes 15 seconds, you haven't given that employee the requisite 10-minute break. You have to give it. You kind of have to start the clock again. So be careful about that. You can't just subtract out the 15 seconds of time that the employee might have responded to that email, et cetera, et cetera. If you don't provide breaks, again, you can be due for fines and penalties and stuff like that. So be careful about it. Let's talk a little bit about vacation and paid time off. So at least in California, there's actually no obligation to give an employee vacation days or paid time off. But if an employer does provide it, and that's going to be most of you, that's going to trigger certain obligations. For example, you have to give it consistently. You can't discriminate against certain classes or against certain people, and be arbitrary about who you're granting time off to. Have a policy about it in your organization. Make it consistent across the board to similarly situated employees, and make sure that it's followed. Unfortunately, just the way the laws are written, it becomes very difficult to make exceptions for people. For example, let's say one of your employees, and maybe this is someone who's worked with you for years, is going to their sister's wedding in Europe. You may be tempted to say, hey, you know what, take an extra week. Be careful about doing that kind of thing, even though it might come from a good place, because you can then open yourself up to claims from other employees saying favoritism, saying discrimination against them, et cetera, et cetera. So unfortunately, a lot of times best intentions can, even result in risk. So, be careful about that. Sick days, by contrast, by the way, at least in California, are required. So if you have an employee who works 30 or more days within a year, you have to provide them with a certain amount of sick days. And there's different methods by which you can do that. You can give what's called an upfront award, which means, in the beginning of the year, you just say, this is how many sick days you have, use them as you will, and when you run out of them, you don't have them anymore. Can be easier to document that way. That's why a lot of people do it that way. There's also, what's called the accrual method, which means that you say, for every 30 days you've worked for me, you get a certain number of days of sick days. And there's actually a minimum that you have to give at least 1 hour per every 30 days worked. That's a pretty small minimum, and I would say that most organizations, you should be aware, do give more than that. I mean, obviously, especially when you're working with clients and patients and in healthcare organizations, you don't want people coming to work sick. So there's, very good reasons to give above the minimum. But that's what they are, and you should make sure that at the very least that's what you're following. So we talked a little bit earlier on in this talk about discrimination. So let's talk a little bit about some of the concerns and some of the ways that we can protect ourselves from some of those claims. So to start, though, it's important to understand a concept called a protected class. And a protected class is a group that's specifically protected from employment discrimination. Happens to be that California has more protected classes than any other state in the country, but every state has a certain number of protected classes. So, the current list for California is race, religion, color, national origin, ancestry, disability, both mental and physical, different medical conditions and genetic information, marital status, sex, gender, and gender identity, gender expression, age, sexual orientation, and military and veteran status. So what that means is if you fall into one of those classes, or if an individual who's your employee falls under one of those classes, then if that individual receives unfavorable treatment, either in hiring, in discharge, in promotion, or any other facet of employment, really, that may be termed employment discrimination. So, what would the employee need to show to prove that? So, number one, like we said, membership in that protected class. They would actually have to show discriminatory intent by the employer. That's a little bit hard to prove, but, going back to my admonition about documentation, you want to make sure whoever the employee is, and it doesn't only go for an employee in a protected class, that if you are making an adverse decision, especially with regard to them, termination, not promoting someone, etc., that you are documenting the reasons why. And that probably starts before the issue becomes acute. That starts on the first day that employee, like for example, arrives late to work. Don't wait till it becomes too big of a problem, because it's going to be really, really difficult to go back and document things that might have happened months earlier. You won't have the memory, you won't have the recall, you won't have the paperwork, you won't have the evidence. And the reason you want to document that is because of this discriminatory intent requirement. You want to make sure you are going to take, by definition, what I would call an adverse employment action against an employee. And it's going to happen because you have to as a manager. You want to make sure, though, that when you do that, you are backing up sound, professional, appropriate reasons for taking that action. And the better you document, and the earlier you document things, the better off you're going to be. Unfortunately, sometimes that means, that kind of leads to a culture of, almost over documentation. But, again, you want to be able to do that. What would have to be proven? Membership in the protected class, discriminatory intent. There would have to be an actual adverse employment action. And then there needs to be a proof of a causal link between the discriminatory intent and the adverse action. And there also has to be damages, which are, probably not that difficult to prove, because if you terminate someone, if you don't promote someone to a higher level position that might carry a higher salary, et cetera, that's going to, satisfy that. And, the remedies for this, you can be forced to pay lost past wages, lost future wages. There can be damages for things like emotional distress, and even the attorney's fees that the employee might have incurred in working a case. There can even be punitive damages. So one thing I would add to a lot of this is, by definition today, we're talking a lot about law and regulation. So a lot of my examples, and I'm, kind of sticking to the different nuances. One thing that I always like to say is sometimes that's secondary. And what I mean by that is you have reputational issues of your organization. Particularly in the addiction treatment space, your brand, your marketing, your reputation in the community is your life's blood. And, having employment-related concerns, even though they may not relate to the treatment of clients or any kind of delivery of care, it's a small world. It gets out there. These things can be very public. So even setting aside the legal ramifications and monetary ramifications of things, yet another reason that you want to stay on the right side of a lot of these requirements. So, definitely keep that in mind. So let's talk a little bit about, how we protect ourselves and try to prevent, these kind of discrimination claims. So the first way is have a written anti-harassment policy in your policies and procedures. There's a lot of great examples of these. These are easy to find and publicly available information. Actually in California, nationally, you're required to take, any reasonable steps to prevent harassment from occurring. And that's in the Fair Employment Act. Having a stated policy anti-harassment has been seen as evidence of fulfilling this. So, no matter what size organization you are, have a written policy that spells out protected classes, creates a complaint process or a disciplinary process within the organization, so you don't have managers doing things differently, inconsistently from one another or with respect to different employees. That's what can really open yourself up to some jeopardy and liability. Have confidentiality provisions. Have guarantees in your policies for a fair and timely investigation. Designate someone in the company to oversee this process. And very, very important, have an anti-retaliation policy, basically saying that, reporting some kind of discrimination that's going on in your organization will not result in any kind of retaliation. You definitely don't want to open yourselves up to a claim by an employee that they felt intimidated, they felt that they would be retaliated against if they came forward and spoke honestly about a discriminatory situation or really any other kind of legal violation. So these are really important, sort of low-cost, high-benefit things you can do to help protect you and your organization. Sexual harassment training. So in California, you need to have 50 or more employers have to provide that kind of training on a periodic basis. There's some regulations that relate to, what that training has to constitute and who should do it. It's true in a lot of states. I would encourage you, you may not be 50 employees, have that training. It may not be a strict regulatory requirement, but again, the fact that you're creating a culture where it's being communicated very clearly that discrimination of any kind is not permitted in your organization is going to serve as a defense for you. And also, you are going to educate employees about situations that they may not have considered to having been discriminatory, and help them make the right choices through that kind of training. So again, policies and procedures and training. So let's say it comes to it though. What do you do? How do you respond to a case of harassment? So the first thing I would say is, if you have a bona fide case of harassment, and what I mean by a bona fide case is, you've gone through your policy and procedure process. The responsible person in your organization has done an investigation, and it's become fairly clear that you have, a credible situation. Certainly be true if the person hired a lawyer and you received a lawsuit or you received a demand letter regarding the harassment. Call legal counsel, talk to an employment lawyer, talk to someone who knows what to do. And I say this because the timing, the nuances of responding to these kind of cases are really important. And as expensive as it might be to hire an attorney in that kind of situation, you are probably going to save yourselves money in the long run. So definitely do that. And, act swiftly, act decisively, act transparently. And that's going to help in both the short term and the long term. And what I mean by that is if you need to separate someone from their manager, do it quickly, do it decisively, do it transparently. If it's clear that there's a situation where there's a bad relationship, even if it doesn't reach the level where that harassment would have been proven, separate those people. Try to reassign an employee to, a place where that if there were harassment, it's not going to be ongoing and that employee feels safe. It's not going to hurt you in your overall legal claim. It's actually not admissible when you do something like that. The lawyer for the other side can't come back and say, well, you reassigned them. That's why. Doesn't that prove that you knew that there was discrimination? That's not the case. Do it anyway. Do it because it's the right thing to do, and do it because it's going to protect yourselves from risk. So, a couple of other things. You already have your policies and procedures, and you've done your investigation. Also think through, big picture sense, on a yearly basis, your policies. Are they working? Are they clear enough, or are they ambiguous? Do they need to be rewritten? Make sure that you're taking a proactive step with respect to a lot of these things. Don't wait for a claim to happen. Take a proactive step. And again, that's because it's the right thing to do. It's going to prevent problems. It's going to detect potential problems, but it's also going to serve as a defense for you that you can prove and document this, that you've done that on a periodic basis. A couple of things to think about as well. Retaliation, big no-no. Make it very, very clear in any steps you're taking, with regard to a complaining employee about discrimination, that nothing you're doing is retaliatory. So if you need to reassign that person for logistical reasons, make sure that employee, and that you're documenting the reasons why, and that it's not a demotion or something like that, because that again can be seen as retaliatory. I would also say, add to this, given the theme that we were talking about before, do damage control, both internally and externally. Speak to the right people. Make sure, these things are going to get out. We all try to keep confidentiality to the extent you can, but be transparent. Make sure your employees who need to know what's going on do know what's going on, and that they have the confidence that the right and correct steps are being taken. Think about acting in a way that that alleviates risk, and make sure that you're getting the right guidance and the right advice for people. So on that note, we talked a little bit about documentation, and specifically, when you have an employee with disciplinary type of issues, how you should proceed. So let's think about the issue of documenting employee behavior. So, again, like I said, do it consistently. Don't wait till right before termination. Any kind of evidence or write-ups or any kind of probationary things that you're doing is going to be sort of less weighty and less taken seriously, if you really only started on them 24 hours before a termination. If you can show a pattern and practice of bad conduct and behavior over the course of months, if you can show that you spoke to that employee, explained to them their misconduct, encourage them to fix it, told them that you'll be, evaluating them in another couple of months, that's all going to be to your benefit. The important thing to remember is that even small infractions can add up to support your justification for an adverse employment action. So resist the urge to, ignore a lot of little things, because you might look back in a year and say, this person really deserves to be terminated, but it's going to be a difficult one because I never, I never really told them they shouldn't come back late from lunch, et cetera, et cetera. And then, you hurt yourself from a defensive perspective, but you also hurt yourself from an employee management perspective, because everybody sees that in your organization. And when, a certain employee is seen as getting away with things, first of all, it encourages other bad behavior, and also can hurt morale and among your employees. So be really careful about the effects that some of this stuff could have. Establish a policy for what gets written up and what doesn't. You make sure you're treating everyone the same. Just because something, I would say, is an oral warning, doesn't mean you can't document the fact that you've given an oral warning. I think people tend to get caught up with, well, if I just tell the person orally, going back to this example of coming late for work, there's no evidence of that. Well, you can write that up. You can have one of your colleagues with you when you give that oral warning as a witness, and then document that that's been done. It doesn't always have to rise to the level of a written warning. It can be, I guess, slightly more weighty if it is, but it doesn't have to be. And you can, everyone manages in a sort of different style, and it might be more appropriate for you and your organizational culture to talk about things orally more than in written warnings, which, can sometimes escalate a situation more than it needs to. It's a good idea to have employees sign on to written warnings, and even sign on to coaching opportunities. What I mean by that is, if a person is has issues, let's say, with relations with potential clients, well, document the fact that you've coached them on that and provided a training for them on something like that. Maintain, and the other thing I would say is, just because an employee leaves your employ, don't immediately throw out their personnel file. The statute of limitations, at least on California, for a lot of the types of claims that can be brought by employees is 3 years. So keep them for more than 3 years, because you may think that you're not going to hear from that employee ever again, but it could be that 2 years down the line, you catch a lawsuit from the employee who just got, might have had a hard time finding a similar position, and it just didn't come out that they're angry about, the separation from your organization until then. So, that can be, and by the way, 2 years down the line, it's going to be much more, even more important that you documented things, because your witnesses, other employees, et cetera, may have moved on to other positions as well, and it may be really difficult to get them to, recall or come in and testify on your behalf about the behavior of somebody. So, be sensitive to that as well. So let's talk a little bit about the issue of severance pay. A lot of people ask me from time to time, do I have to give an employee severance pay, et cetera, et cetera. So, severance pay is not required unless it is by some kind of contract that you had with the employee, but sometimes it might be a good idea. And that's because, you can offer severance pay in exchange for the employee waiving certain claims that they might have against your organization. So be very careful about this, because there's a lot of state law nuances in this. And there are requirements, for example, in California, that these potential claims have to be stated very clearly as to what they are. So, don't just willy-nilly go off and offer someone a certain payment in exchange for waiving claims. These things have to be documented properly, and different states have different rules as to what kind of claims can be waived, and how you have to reach an agreement about that and document that agreement. So, final paycheck, as well, this comes up a lot in terminations, because often you need to terminate someone with immediacy, and it might not be, at payday. or a person resigns out of the blue, sometimes as a result of some kind of adverse employment thing that's going on. Do your best to issue that final paycheck with immediacy. It's especially true if you make a termination. In California, though, you do have 72 hours following the employee's notice to pay that final paycheck. Again, it can be different in different states, so be careful of that. And make sure that with that final paycheck, in addition to regular compensation, that you're also reimbursing that employee for accrued and outstanding business expenses. If there's accrued paid time off, you'll probably have a company policy as to if and how that gets paid out, and any other benefits that are owed by the employee. So be very careful about that, because your final paycheck isn't final really until it includes all of that. And, again, there's waiting time penalties, at least in California, if you don't timely pay someone what they deserve on their final paycheck. And that's true in a lot of states. So, be careful about that. Let's talk a little bit about non-competes. This is something that's really a creature of state law, so you have to be very sensitive to how these apply. And what a non-compete is, very often an employer is in a pretty competitive field, and, they don't want their key employees going off and working for somebody else if they leave their organization. And, there's some good reasons for this. A lot of times you're sharing confidential information with an employee or different kind of business practices, and you want to make sure, and it stands to reason why an employer wouldn't want someone to come in, work for them for a month, learn all their trade secrets, and then go work for a competitor. In a lot of states, though, these are really difficult to enforce. The law kind of frowns on limiting an individual's right to work for a certain employer. Under California, they're generally not enforceable. And, there are a few exceptions to this, which are, for example, a trade secrets provision. You can mandate that an employee not divulge any trade secrets they've learned at your organization, confidentiality information, things like that. And you can go ahead and enforce that. Difficult to prove, but it's probably something you should have in your employment contracts. I think it's a best practice, and keep that in mind. So let's hit one last thing, and that's job references. And this is a question that I hear a lot, because giving someone a reference for a position can be dicey. A lot of times someone leaves your organization because things weren't exactly going well, even if it's not purely a termination, and even if it's not a resignation that was fully as a result of dissatisfaction. Often there's elements in that, and there's nothing. Although there's really no law that prohibits you from giving an honest review, you can open yourself to a defamation claim if you say something that is a misrepresentation or not true. And that's difficult because, obviously that can be a little bit subjective in the eye of the beholder. So for that reason, many times employers will take a position from a policy perspective that they will only confirm employment. That means dates of employment and position and title, but they won't give either a positive or a negative reference to an employee. Think that's something that you want to think about internally in your organization of what works for you. It can be a little bit of a harsh kind of policy, but it's one that I see increasingly a lot of organizations are doing. And so with that, we're gonna close for today. I hope you all enjoyed the information. Again, just to repeat, a lot of this is can be California specific, and a lot of employment laws are creatures of state law. But the issues that we raised are certainly common everywhere. And I hope you use the information to sort of, become sensitive, become aware of a lot of the concerns regarding addiction treatment and employment. And, when you do have questions that need to be answered, that you go to the right people, and that, first and foremost, and really mainly, that you establish, an organizational culture that's compliant with these kinds of things, because that's not only going to shield you from liability, but also create a stronger organization, from a business and delivery of care perspective as well. So thank you all very much for your attention today, and have a great rest of your day.
You've just finished listening to another exclusive continuing ed podcast by Clearly Clinical. If you like what you just heard and you need continuing ed credits, please visit us at clearlyclinical.com to check out our one-year membership, where you'll have access to our growing library of continuing ed podcast courses. Clearly Clinical, where our goal is to help you learn, grow, and shine.